case briefs, and so much more. LSData's got what you're looking for.
In 1969, the Superior Court of Pennsylvania heard a case called Gallagher, Magner Solomento Inc. v. Aetna Casualty Surety Company, which centered around the issue of reimbursing someone who paid another person's bill without an agreement for repayment. The lawsuit arose when an insurance brokerage firm paid $2,300 to repair a building damaged during excavation and underpinning work done by the company's client, and then sought reimbursement from the company. The company, Aetna Casualty Surety Company, claimed that the brokerage firm acted as a volunteer, thus having no standing to sue for repayment. Initially, the jury returned a verdict in favor of the brokerage firm, and the company appealed the decision. The Superior Court was tasked with determining whether the brokerage firm had the right to seek reimbursement, or if they were indeed acting as a volunteer. Ultimately, the court decided that the firm had acted as a gratuitous volunteer, meaning they had no standing to sue the company for reimbursement. As a result, the Superior Court reversed the original verdict and ruled in favor of Aetna Casualty Surety Company, denying the reimbursement claim by the insurance brokerage firm. This case set a precedent for future cases dealing with the issue of volunteer payments and the right to seek repayment for such transactions.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.